where enforcement and real losses usually arise: illegal charter, maintenance pressure, and sanctions. Hello, yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss the issue clients usually feel only after the financing closes, where the real enforcement and loss exposure most often arise. The important point is this: most enforcement connected to financed large turbine aircraft does not arise because a promissory note was drafted badly. It arises because economic pressure changes operational behavior. The first and most common danger zone is illegal charter and disguised compensation for higher activity. When an owner wants revenue to offset carrying costs, when a management company wants utilization, and when passengers want lift without charter level friction, the temptation is to stretch a dry lease, a time-sharing arrangement, or a management structure beyond what the rules allow. That is why the paradigm matter remains such an important example. In 2021, the Department of Transportation entered a consent order finding that Paradigm Air operators engaged in air transportation without the required economic authority, directing it to cease and desist and assessing a compromised civil penalty. The order is especially useful because it shows how regulators analyze conduct in the real world. Holding out, demonstration flights, broker involvement, and revenue activity can matter as much as what the contract is called. The same lesson appears in FAA Safe Air Charter guidance and in the government's sham dry lease cases. In other words, many aircraft finance disputes become enforcement matters when owners try to convert an expensive private aircraft into a quasi-commercial revenue asset without building a lawful commercial platform around it. The second danger zone is maintenance under financial stress. Cash flow pressure does not repeal 14 CFR section 91.403. The owner or operator remains primarily responsible for airworthiness. And under 14 CFR section 43.13, falsification or alteration of maintenance records can support certificate action. In finance-driven disputes, I often tell clients this: the law is remarkably unforgiving when someone tries to solve a liquidity problem with a logbook. A practical example is easy to imagine because it happens in many forms. A borrower is approaching a major inspection, engine event, or program true-up. The aircraft is valuable, but only if the records remain clean and the maintenance status remains current. Someone delays required work, overstates status to a buyer or lender, or cleans up the books after the fact. Now, that's no longer just a technical discrepancy. It becomes a regulatory, civil, and even criminal problem very quickly. The third area of concern and danger zone is international movement and sanctions compliance. BIS states that aircraft manufactured in the United States or foreign manufactured aircraft containing more than 25% controlled U.S. origin content can be subject to license requirements if destined for Russia. And BIS has publicly identified commercial and private aircraft involved in apparent violations. In a large turbine context, that means lenders, lessors, and operators and principals all need to care where the aircraft goes, who controls it, and who benefits from the flight. Those issues, they're not abstract. A cross-border aircraft can expose counsel to export control, sanctions, repossession, insurance, and registry questions all at once. A financier that understands only that the note and not the mission profile is underwritten is only looking at half the transaction. So, where do most serious problems arise? Not from the existence of financing itself, they arise, again, at the seams between ownership and use, between lease language and crew reality, between maintenance budgeting and airworthiness, and between cross border movement and compliance screening. Here's a point to remember: aircraft finance usually fails at the moment economics overrule discipline. The preventative strategy is therefore straightforward, even if the execution is hard. Underwrite the operator, not just the owner. Match the finance structure to the lawful operating structure. Verify recordation and registry filings. Audit the maintenance status before and after closing. Track engine program obligations. Screen counterparties and routes. And revise the structure before a revenue idea, management change, or international trip quietly transforms the risk profile. In large turbine aircraft, the financing closing is not the end of the legal work. It's the beginning of the surveillance obligation and a need for ongoing follow-up. In short, the most expensive aircraft financing mistakes are rarely surprises in hindsight. They're usually visible in advance in the form of a sloppy structure, optimistic assumptions, weak records, and conduct that no longer matches the documents. I'd like you to remember this: in large turbine aircraft finance, the biggest risk is not leverage, it is misalignment. Thank you again for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues and answer your questions with precision.